Well, hello. Sorry about that switch up. I had set up a live that I was going to do, and then I went to check to make sure nobody that I knew was going live at the same time because I didn't want to do that. And I saw that Lauren was live, and then I saw that she had invited me to her live. So I ended up going there instead, and I didn't get this one closed out. So it's still listed too. So I'll go back later and change the thumbnail for the other one. But this one is actually what mine was supposed to be, and it's about what the standards are. So we've gotten all these requests now for what they want to continue to have sealed. So I'm just going to do a quick Law Nerd Live about what the standard is that Judge Lyman is supposed to consider when he decides whether or not to grant it. So I mean, ultimately, it's left up to him, but I can show you what he is supposed to consider. And beyond that, that's all up to him. So, this case, this is, and if you've been watching for a while, you know what binding authority is because it's something I've talked about a lot. So, binding authority is when a higher court has made a ruling on a subject. The lower courts are bound by that case, by that judge's decision. So, for example, Judge Lyman is in a district court. That's the lowest court, the lowest level court in federal court. And above that is the Court of Appeals for the Second Circuit, because they're in the Second Circuit. And then above the Court of Appeals of the Second Circuit is the U.S. Supreme Court. So every decision that the Court of Appeals makes, if there's been a decision made by the Supreme Court on that kind of subject already, they are bound by that authority, and then it kind of trickles down like that. So if you noticed in a lot of the documents, they kept quoting Nixon, they kept quoting this one, Amodeo. The reason that they're quoting those is because those are a standard. So even if the case isn't exactly identical, if the same decisions have to be made, they have to go by those standards. And that is supposed to be, that's there to make everything level and even across all of the federal courts, across all of the states. So, and then when you have these specific standards, it helps the judges not just rule how they feel like ruling. It's supposed to keep, no matter what circuit you're in, the decisions all unified. So that's why you'll see these same cases keep getting quoted over and over again. And there's a couple more that I didn't cover. I chose this one because it's the more important. It's Second Circuit. And I mean, it's below Nixon, but this one is the one I chose to go through. So this was decided in 1995. It is a leading Second Circuit decision that limits blanket secrecy of court records. So you can't just say what some of these people are trying to do is keep this all a secret, keep this all sealed. You cannot do that. And so the panel in this Court of Appeals held that courts must apply a document by document access analysis. So that means that Judge Lyman has to go through each and every one of these documents, or he's supposed to, and do a document by document analysis. And I don't know when he's going to have the time for this, but that's what this ruling mandates. So to try to determine about the sealing of the materials, whether or not they need to just be completely unsealed, or if they need to be redacted, or if the scope needs to be more narrow. And he hasn't given himself much time for this. And this is his own fault because he gave them so much time to do this. He extended it twice, and he extended it beyond what Blake even asked for, and Blake already had asked for too much. But now he's done this to himself because he's promised us that before oral arguments, this will all be unsealed. So that's the 22nd. And today, well, it's now the 6th because it's past midnight. That's all the time he has to get through this mountain of redactions and requests for sealing from all of these parties and third-party people who submitted tonight. So, and according to binding authority, this is what he's supposed to do, is go through document by document. So where he's going to find the time for this, I don't know. I agree, Isabela's gross because of this. And here's the thing. Right off the bat, I want to say, if these people are going to be witnesses, if they are going to come to trial and testify, this is just plain silly for them to ask to keep their entire information just completely sealed. Because at some point, they're going to have to sit in that witness stand and talk. And that's not going to be sealed. So this is such a waste of time for them to think that they can just keep everything sealed. They are really trying to do what I coined celebrity privilege. That they've been granted so far in this court, and now they've gotten used to, but it's not the way it's supposed to be. So I'm not going to pay a whole lot of attention to chat just because it distracts me. And I don't want to keep you too late because it's already so late. And this is all legal stuff. So I want to kind of go through it a little bit quickly so I don't bore you to death. So, but I will give you time to chat at the end. But I do, like, my brain will wander off if I start reading the chat. So let me get my notes ready. So this case, like I said, it was decided by the Court of Appeals in the Second Circuit. And the original case was being fought in the Southern District of New York, where this current case is being held. And it had actually two appeals that were heard by the Court of Appeals. One was heard in January and the other in December, both in 1995. So this Newsday, well, let me just read this part. One appeal pressed for broader public access. There were people that petitioned the court. They wanted things unsealed. And then the other case challenged the form and the scope of the release and the redactions decisions that the district court had made. So this is all about non-parties and affected interests objecting to the release or the manner of redaction. So it's very, very related to what we're seeing now. Even though there are a lot of differences in the case, it's the same thing. So both appeals turned on the same core access questions. So there is a report that was made. So this one isn't about depositions. It's about a report. And it's about whether or not this report was what's called a judicial document, which you will understand, and you're going to walk away from this live fully competent to explain what a judicial document is in just a few moments. So you'll also be able to understand what the access standard is, because that's what gets talked about here, and whether the district court made adequate, particularized findings. But each of these appeals framed the issue from a different posture. So one was about a motion to unseal, and the other was about the terms of release and redaction. So, but they are all under the same case. So this first part was about other people telling the court, unseal this, unseal this. And this is the one that happened in January. So it was a non-party appellant, cross appellee Meyer. And sorry, hold on just a second. Okay, sorry. I took a drink and then I ended up choking on it. So anyway, so this is a criminal case. So that's one of the big differences. But one of the things about this report is that it had unsubstantiated information. So the things in it were not told under sworn oath. So things like a deposition, the people who have spoken in a deposition, they have taken an oath. Or if you've put an affidavit, that's under oath. But this report just had some things that people hadn't sworn to. So there was no way to verify whether or not it was true. So that's one big issue that's different about Blake, that and the fact that it's a criminal case. It also contained the names of confidential informants. Those people are protected. So there's not anything like that in Blake's case. So keep that in mind that this case we're talking about here has a lot more going on than Blake's little civil case. So her case wouldn't even be, what am I trying to say? Like, this case was much more important to keep certain things sealed than anything in Blake's case, is what I'm trying to say. So they asked for this sealed report to be opened up. So what does that tell you? It tells you that the public can make demands to a court. And you're gonna learn like why I'm okay being so hard on Judge Lyman. That's another thing you're gonna be able to explain when I'm finished with this. So after Newsday, and they're the ones who moved to have this unsealed. So after that, the court submitted an edited and a redacted copy to the court in camera. It was an in-camera review. And then the district court, after they held the in-camera review, they ordered it to be released with modifications made by the court officer. And so that's what they brought to the appeals court, because they said, no, we don't want to unseal this, and we've got these reasons. So that's what brought them to the appellate court in the first place. Okay, so there are a couple of other things you're going to learn. Common law right of access. That's the principle that we're talking about here. So that common law right of access is us. What we have a right to see as the public, as citizens of the United States, we should have access to the court. So that's the principle that this standard is set in order to explain or set up. So they had determined, the district court, the Southern District of New York, had determined that this common law right of access applied. But let's see, let me skip some of this. But then on this appeal, they said, well, we've got law enforcement rights here because it was a criminal case. There are privacy rights here. And so that is actually more important. And so the Court of Appeals affirmed, they agreed that the district court made a mistake. And so they reversed in part and they remanded with instructions, which remanded means they sent it back to the district court to fix it. Okay, and then so this common law right of public access, that's our right to have transparency, to see these things that are filed publicly, predates the Constitution. And the US Supreme Court has itself said, it is clear that the courts of this country recognize a general right to inspect and copy public records and documents, including judicial records and documents. The interest necessary to support the issuance of a writ. Now, a writ is, let me try to make it as simple as I can. So it's something that's submitted to either the local Supreme Court or the US Supreme Court, and it's to ask them to write an order to direct the lower court. So if it's something that they're doing that they need to stop doing, or if it's something that they need to do, that's what's going to be decided. But the writ is the order that you're requesting of the Supreme Court. Excuse me, hold on a second. So they say the interest necessary to support it has been found. So they're saying, yeah, you've got a case here with us. So we're going to consider this. In the citizen's desire to keep a watchful eye on the workings of public agencies. That's what we're doing. We are the watchful eye, and this court that we're watching is the public agency. And we have a constitutional right to do that. So not all discovery qualifies, though. So just because something is filed in court, so all this discovery, for example, we don't get access to all of this stuff because of this. Just because it's been filed doesn't mean we should get access. Because, like in their case, there was stuff that was submitted that couldn't be verified. It wasn't given under oath. Some of it's sketchy. We know in this case there's lots of sketchy stuff because the plaintiff herself has misrepresented things to the court. So, not everything that's in discovery do we have the right to public access to. So they say we think that the item filed must be relevant to the performance of the judicial function and useful in the judicial process in order for it to be designated a judicial document. So what does all that mean? Because this is the key. So that you have to weigh competing interests, and it covers things like protecting trade secrets, privacy, reputations of victims of crimes. Now, in this case, we're not talking about a crime. This isn't a criminal case. As well as to guard against risks to national security interests and to minimize the danger of an unfair trial by adverse publicity. You know, kind of like a New York Times article that comes out with unverified information and absolutely obliterates multiple people's reputation. You're not supposed to do that in a court, but apparently it's okay if you do it in the New York Times. Or at least Judge Lyman seems to think so. Okay, so in their decision, they say it is proper for a district court, after weighing competing interests, to edit and redact a judicial document in order to allow access to appropriate portions of the document. The district court should make its own redactions supported by specific findings after a careful review of all claims for and against access. So that means all of these things that were submitted tonight, they have to be they're supposed to be carefully reviewed. And we know that coming up, is it the 12th, I think, is when the responses to these are due. And those are supposed to be carefully considered as well. So by the time that's done on the 12th, that's only 10 days before oral arguments are supposed to take place. So again, like I said, in helping Blake, he has kind of put himself in a really bad position. He gave her all this extra time, more time than she even asked for. And now he has so little limited time to review all of these. And he's supposed to. Okay. But you saw the kinds of things, like that was important. It's talking about private business interests and national security interests. We're not talking about, oh, don't say anything because my friends are celebrities. These are serious reasons. And so they say we affirm as a judicial document subject to the common law right of access, we remand the case to district court. Any restrictions on access should be supported by specific findings. So what they're saying is you can't just restrict anything. Your restrictions should be supported by specific findings. And that should apply to Judge Lyman as he goes through these. He can't just look at them and say, oh, okay, we're going to grant this. He has to support it by specific findings. And we're going to go through how he should weigh that. And the burden is upon Meyer, or in this case, it's upon Blake, to demonstrate that the interests favoring non-access outweigh those favoring access. Then we have the second one from the same case that was filed in December. And it's about the same report. So he remands it back to the district court, and then the district court makes another decision, and they end up back in the Court of Appeals because they're like, no, you still don't have it right. And so this appeal goes back to Judge Patterson's order releasing a redacted version of a sealed investigative report filed with the district court. So this time they reverse in part. So they say, okay, we made this decision last time, but we don't agree anymore. We're going to reverse part of it and then remand in part. So the reasons are, as they say, somewhat complex because it requires a weighing and careful consideration. It says our previous decision established a presumption favoring access to the report because they are supposed to be transparent. But Meyer had the burden of overcoming that presumption. We now address the standards to be used in balancing the presumption of access, because they turned it back over to the district court, but they didn't really give them instruction on how to carry it out. So now they're like, we're going to try this again, but this time we're going to give you the standard to use. So the reason that they reverse on part one is because they say that part one of the report would provide little meaningful information because the redactions are so extensive. Or if it's questioned, if it's responded to, it could cause these confidential sources to be identified. So it was in part protection of confidential informants, and in part because the redactions were just so extensive that there's not going to be any meaningful information anyway. And so they reverse and say, do not unseal part one. But they don't just say, just seal everything. They still say part two needs to still be unsealed because it doesn't have the parts in it that part one had that need to be protected. And so when the court can, it always should allow for access. So they call it a presumption of access, meaning you go into this assuming everything should just be out there for the public. And then anything that is not has to be argued for and ruled upon. So the presumption, everything should be just presumed to be out there to the public. And then, unless the documents, or especially if the documents are deemed to be judicial, and this is what I was telling you about, judicial documents. Now, what does that mean? Here's the important part. The presumption of access is based on the need for federal courts. So this is all about federal courts. Why? Because federal courts are independent. There's not someone checking over them. Like in a state court, there's a Supreme Court, a state Supreme Court, but federal courts do operate very independently. Federal judges have a lot of leeway to make decisions on their own. And that comes with danger, the dangers that we have been talking about. So their accountability comes from where? It comes from the public. And they have to operate in a way to keep the public's confidence in the administration of justice. The power of federal courts comes from Article 3 of our Constitution. Sorry, I've gone ahead without my notes. Where am I? Okay. So it comes from Article 3. So these kinds of things are spoken about as being under Article 3, and that's what it means. So these things impact all of us. And then it points out what I've been saying, that judges once nominated, federal judges, once nominated and confirmed, serve for life unless impeached through a process that is politically and practically inconvenient to invoke. And I think they use the word inconvenient when it should be impossible, because it's nearly impossible. In all of the time that we have had federal judges operating in this country, only 15 have been put up for impeachment. And of those 15, only 8 have actually been removed. That is a very small number, especially when you consider that federal judges go across the entire nation. And only 8 have ever been removed. I mean, some states have had beyond that number just in state judges. So this is, it really shows how difficult it is to impeach them. So that means the public is in charge of this. So although courts have a number of internal checks, such as appellate review by multi-judge tribunals, professional and public monitoring, that's us, is an essential feature of democratic control. Monitoring both provides judges with critical views of their work. That's what we're doing. That's why what we're doing is okay. We have every right to criticize him. It's our duty, actually. And deters arbitrary judicial behavior. So this, the way this is all set up, it's recognized the kind of power that federal judges have, that it can become arbitrary, and that the public and their critical views are what deters that. Without monitoring, moreover, the public could have no confidence in the conscientiousness, reasonableness, or honesty of judicial proceedings. Such monitoring is not possible without access to testimony and documents that are used in the performance of Article 3 functions. So do you see where I'm getting with this? Like, we're doing our jobs here. This arbitrary behavior is supposed to be pointed out by the people. So what does deemed to be judicial? I had highlighted that in green here because that's what it was talking about, the documents. These are the ones with the biggest presumption to being accessed by the public if they're deemed to be judicial. So it's really important that we understand what that means. So courts use a functional test rather than a formal label, and it's these factors that get included. Is it filed with the court? That's just the first one, because many, many things are filed with the court. So it's not that by itself. Has it cited or been relied on by a party in a motion, for example, in support of or opposition to summary judgment? So all of these things that are being considered right now, these were filed in response to the motion for judgment on the pleadings, or a motion, or no, that's oral arguments, is putting them all together. But a lot of these are in response to the motion for summary judgment. So this is exactly what it's talking about. That's one of the criteria to be considered judicial. 3, used by the judge in reaching a ruling or otherwise playing a role in the adjudicative, I always have trouble saying that word, process. Is he ruling on this? He is. It's a summary judgment document. It's been filed with the court. And number 4, necessary for meaningful public understanding of the court's decision. He's going to make a decision, and if we don't get to see what his decision was based on, we will not understand his decision. So we can check all 4 of these off. And that makes these documents deemed to be judicial. If the answer to these is yes, the material is likely deemed judicial. Now, what that means is we got another step to go through. Because what do you do after that? Does that just mean everything that's mentioned needs to be unsealed? Well, no, unfortunately. Because after that, there's a weighing that has to be done. So if these documents are deemed to be judicial, the presumption of access is based on the need for federal courts to have a measure of accountability and for the public to have confidence in the administration of justice. We just read that, and they've repeated it twice. And this is all from the same document. This is the Second Circuit's Court of Appeals decision about this. And this is all directly from that. So this is the binding authority that he has to consider when he makes this decision. So this isn't my words to you. This is straight from his binding authority and what they've said. So the federal court exercises powers under Article 3, which is the Constitution, the highest legal authority in the nation, that impact upon virtually all decisions. And then it kind of repeats again what we just read, that they're confirmed for life unless they're impeached, and that it's very difficult to invoke that impeachment. And oh yeah, I read this too soon. I put this in there twice and I forgot. I already read this whole thing. Sorry, I just saw what if 3 or 4? It could be enough to be 3, but 4 is stronger. And then it's not done there. So it's not like if it passes all of those, that's it. So an adjudication is a formal act of government, the basis of which should be subject to public scrutiny. So his decision on these documents is part of this. So they're saying we noted them as binding authority, Second Circuit Court of Appeals. We noted that a denial of access to such materials might raise serious constitutional issues. So, Lauren, is this where I can purchase milk after hours? Oh my goodness. Oh, I forgot to give you a link. Did you want a link, Lauren? Or I think you said you were going to be going to sleep. So let me know if you change your mind. Let's see. So we have also consistently held that the public has an especially strong right of access to evidence introduced in trials. So we've already gone through those 4, and now we have this. Are these people going to... Sorry, Lauren's being very distracting. I'm in bed. Please talk at me until I fall asleep. Okay, you're going to be so smart by the time we finish this. So are these people going to testify in the trial? If they are, their stuff is going to come out anyway. So that has a big bearing on this decision as well. So the strong weight to be accorded the public right of access to judicial documents was largely derived from the role of those documents played in determining litigants' substantive rights, conduct at the heart of Article 3, and from the need for public monitoring of that conduct. So they're saying all of the things that are important to be considered when you make this decision. And you will note that none of the standards have anything to do with whether or not you're a celebrity. If you've been listening to my channel for a while, one of the things that you've learned is that when there's something that needs to be decided again and again, something that's going to be across the whole country decided, they like to come up with like 2-prong standards, 3-prong standards, so that they can ensure that federal courts across the nation are all using the same standards to make their decisions. And then you don't end up with things being done so differently from one circuit to the next. So usually there's a balancing test. So if you remember, like when I was subpoenaed along with all the other content creators, I talked about how our First Amendment rights have to be processed first. First, you have to get past that right. And then there was a balancing of whether if they could beat that standard, which is very hard to beat, then they had to weigh the harm to me or all of the rest of us compared to the harm that it would cause Blake not to reveal it. So that's what I mean by balancing. So we've got through the first part, the standards. Now we've got to get through what this balancing is. So is that document or deposition or whatever that that is being sought to be unsealed, does it invoke the court to use its powers or affect its decisions? So a motion for summary judgment does. He has to use his power that he's been given through this court, through the Constitution, through Article 3 of the Constitution. Oh, I got to stop looking at the chat. So he's got to make a decision. He's got to use that power to make the decision. So, yes, the answer to that question is also yes. Now, what are the other factors that have to be balanced with that? We've already determined quite a few to determine that this is a judicial document. So now what does it have to balance with? Danger of impairing law enforcement or judicial efficiency. We don't have law enforcement in this case because it's not a criminal case. But we do have privacy interests of those resisting disclosure. So all of the ones that have made filings today and said, we need this protected because of our privacy interest. This is where the balancing comes in. So just because some information is private, now some of it is automatically granted. So the personal identifying information, people's phone numbers, people's email addresses, their home addresses, that goes without saying. But some of this other stuff that they're claiming is their privacy, that's what has to be weighed. Is it really? Because they're all claiming it. And they're all citing the same cases to say, and using the same language to make it sound like it is. But is it? And that's where factors like, well, are you going to testify to this information in court anyway, come in? Because if you are, what's the point? It's not going to be private. Or are you just asking for this because you're a celebrity? Because that doesn't cut it. So one of the weighing factors about that is the subject matter traditionally considered private rather than public? Is it something like financial records of a business, family affairs, illnesses, embarrassing conduct, not just embarrassing conduct, but embarrassing conduct with no public ramifications? So these kinds of things truly are personal. and private. But not everything that these people are saying is private is actually private. For example, Blake, if you were in Lauren's live, you saw that she wants her conversations with non parties to be protected. Well, you can protect the identity of those people that you spoke to, but if you said something, you're not protected. You're part of this. You brought this case to court. How dare you ask for this protection? Yeah, we can protect the people that you said it to, but you don't get to protect the garbage that you said about Justin and Jamie. You don't get to protect that and claim that it's to protect third parties. You can easily redact the name of who you said it to, but that doesn't mean that what you said to them is private. Okay, and now they're talking specifically about the report that they're reporting on, is that there's two parts of it. The accusations are all unsworn. So, like I said earlier, a deposition, an affidavit, those are sworn testimony, sworn statements. But if it's just something somebody said, it's unverified. And if they put that out there and it's got the weight of being a court document, these rumors that are unverified could be put out and bring harm to people. Like I said, very much like the New York Times, what they did. They just put that stuff out there. Well, a court isn't supposed to do that. But the other part is they said that it's so heavily redacted because so much had to be redacted that there really isn't anything there anyway. And some of the redactions were identities of court officer sources or confidential informants. And so they said that runs the risk, if questions are asked about it, of their identities somehow coming out. And so he says that names of firms or other unions, sorry, excuse me. Sorry, I clicked the wrong thing. I clicked the slide instead of my microphone. Okay, let's see. So they're saying this unverified information that would put the person who it's about in the unfair position of choosing between suffering the accusations in silence or revealing redacted information. So in that case, they said that's the part that they reversed because that actually was supported. This is in criminal cases, these confidential informants are protected. And so there's no surprise that this ends up happening in that case. But we're not talking about a criminal case. We're not talking about confidential informants, nothing like that. And another case, now you've probably seen this mentioned a lot, this case. Judge Lyman has used it a lot, actually, when he talks about the importance of public access. I believe he quoted it even like to say why us content creators had to respond a certain way. So this case is another one that was also in the Court of Appeals in the Second Circuit. It's a little more recent. It was in 2006. And this involves certain news organizations who intervened because they wanted access to documents that were filed under seal. And guess what? Chicken butt. A motion for summary judgment. So that would be like us demanding this court unseal this stuff. Saying we have a right to know this as the public. These are judicial documents. Unseal them now. So that's what these news organizations did. I'm so sorry. Hold on. And so they asked the Court of Appeals to determine whether they can appeal a district court order that was not a final judgment. Because normally, if it's not a final judgment, it's not open yet for appeal. Usually you can't appeal until there's a final judgment, but there are a few cases. And so they're asking for permission to appeal this decision, even though it's not final. And the basis of it is the right of access under both common law and the First Amendment. Oh, I got. And so in this case, I didn't get the second one on there. Hold on just a second. Sorry guys, I missed a slide. Sorry about that. Oh, where did I put it? But ultimately, and the case is kind of long, but I didn't include a lot of the information because I'd spent so much time on the other one. But ultimately, this court decides that the newspapers are entitled to the relief they seek. But they kind of go through the same standards and balancing that we just went through with the first case. So we have two. Now let me get back to, I'm not on my screen now. So we have two of these binding authority cases where it was decided in favor as long as it meets the standard of a judicial document and does not inhibit somebody's privacy. The real meaning of privacy in a legal term, not just anything embarrassing that we don't want people to hear, but the real legal meaning of privacy. And they ruled in favor of getting that out there. So what I wanted to say about all of this is that all of these things that they're claiming and people wanting their entire depositions to be kept confidential, or like Blake's ask for conversations she had with third parties, it's too big of an ask. If you weigh it on these standards, it does not meet the actual standards. We're talking about documents that were filed in a motion for summary judgment, and you saw that that's part of it. So after you get through all of those determining factors, and we've gotten through those, now all that's left is for him to weigh the person's, if it's an actual legitimate claim to privacy or not. And all I've got to say to you, Isabela, is 4 words: Natasha Heath birth video. If that woman, as a non-party, had nothing to do with any of this stuff, if she had to hand over something so extraordinarily private as her birth video, you need to stop crying about this because you got yourself involved in this. We have statements. This is another aspect of it that I didn't include in the slide. But if information is already public, there is no assumed privacy. We already know what she said to Justin in text messages immediately after filming about what her experience was like filming. She thanked him for making her filming experience, what did she say? So comfortable. So her remarks are already public. Why is she trying to hide them? And it made me start to wonder, is maybe her testimony not what we think? Maybe she didn't back up Blake. And maybe Blake wants that kept sealed. Because maybe she got on there and told the truth about her filming experience. I mean, that's a possibility. And they don't want that leaked yet because that's going to make Blake look really bad right now. But I don't know if I want to give her that kind of grace but another point that will be, if Isabela testifies and if her story changed from the time, the most reliable information from her was the text that she voluntarily sent to Justin. Nobody asked her to send that to him. Nobody asked her that question. She voluntarily, from her heart, sent him a message, grateful, thanking him, telling him how comfortable she was. That is the most likely to be the true statement. If she makes any other statement, it's going to be so easy for her to be questioned and pictures shown of her snuggled up with Blake in Blake's bed, in Blake's home. We've got ample video of her talking about Blake lending her dresses and jewelry and helping her pick stuff out. We have video that Blake flew her in her private jet to this book bonanza. And Isabela wasn't even supposed to be there. We have talk of her thinking she's going to get introduced to Taylor Swift. We have Brandon out there telling the world that Blake helped him get that job. We have Paul telling the world that Blake helped him in his decision to hire Brandon. What does that look like? Does that not look like favors for support? So that's going to be, so her testimony is going to be the easiest one to pick apart in court. Because we have the best thing is what she said immediately after, of her own accord, not under any kind of duress. No one asked her to make that statement. And then we see all of this time, there's pictures of them out to dinner in New York City. And the weirdest one, like I said, of her cuddled up with Blake in her bed, having a sleepover. What does that look like? I mean, if she changed her story after those events, it's going to be the easiest part of this trial to point that out to the jury. So it makes me wonder how far Isabela was willing to go for Blake. Did she change her story, or did she stick to the story and Blake wants that kept quiet because that's not going to look good for her? And yes, I'm looking at comments now because I'm done with my presentation part. But yeah, the Sony thing, I think that made my night, seeing that Sony does not have Blake's back. They're like, she's putting things out of context. Her expert said this and that, and they are protecting their employees. And they will, of course, because they are responsible for their behavior. They are not supporting Blake. And that is amazing to hear. And that's going to split some things. And it's going to be a big signal in Hollywood as well to see Sony back off and not support Blake. That's going to look huge to other production companies that are out there. And it's just amazing to me, like, how this is all working out, that it has not worked out in the way that she thought it was going to. And it's her own doing, hers and her husband's. And in the end, while they're a draft of the script. Which script, Michelle? Sorry, I wasn't, if you told me earlier, I wasn't looking at chat because I didn't want to get distracted because I'm so tired, and I thought to explain all this without losing place is going to be hard. I'm just going to say, Gaia asks, for her to be shunned out of Hollywood, this trail needs to be televised. Is there any petition that could be put? No, unfortunately. It's the standard. It ends with the script. That's the standard for all federal courts. So, I mean, they would have to have some kind of special permission, but I mean, this is the standard in all of federal courts everywhere. So unless there's something they can do to get permission, I don't even know like what the process would be to even get permission because it's just not done with federal court. We're going to have to completely rely on. Well, the nice thing is that it does take a long time to, especially, and the longer the trial goes on, the longer it takes, but the transcripts do become available. So we won't get to hear the voices and the tones, but we will get to read eventually the transcripts of the trial. But it does take a really long time, especially if it's a really long trial. It takes a long time to get that out. So I mean, it would be, I mean, maybe by the end of the year or the beginning of next year that we would actually have a transcript, and we'll have to buy it. Which I know it will be expensive. Well, no, it's one piece. Yeah, I don't. I've never had to buy one before, like an entire transcript. So I don't know how that works, but you better believe people will be accessing it and distributing it. It's just a shame because we'll have to wait so long. So while the actual trial's going on, we're going to have to rely, unfortunately, on the media. So the good news is I think quite a few content creators are intending to go there and take their own notes so that they can put those out. And usually when you're in the court building, only certain people have permission to have things like a laptop or to be able to use their phones or devices while they're in there. Most of us cannot. I don't know that particular court. I just know my experience in other courts. But they can take extensive notes and then report on it at every break and kind of keep us informed that way. The mainstream media will be doing that, but we won't be able to rely on them. They're going to twist it as they've been twisting everything. Yes, inner city press, I'm sure, will cover it as well. And I think they have permission to have their device because they live tweet stuff. So only select press do. Yeah, Lauren's going. So there are a lot of breaks, and so if they're good at taking notes, they can come out during each break and update us. But my voice is about to absolutely die. I've pushed it to the limit, but I really wanted to get that out tonight because I know I'm not going to sleep. I'm going to be reading all this, and so if I wait till tomorrow, it will be late tomorrow. But anyway, thank you guys so much for joining. I can't believe that many of you are here at after 2 a.m. for a lot of you. But I know we've all been waiting for these documents. And so hopefully, now he promised that these would all be unsealed by oral arguments. And that's the 22nd. So we should be getting some things unsealed pretty quickly. Hopefully he doesn't like hold them all back and then do it all at once. Hopefully like he goes through documents one by one and as soon as they're done, submit. But we'll have to see. But just so you know, now you are well informed about what the standard is that he is supposed to follow when he makes these decisions. All right, everybody. Thank you, Lena. I don't know if she's still here. I don't see her anymore, but I know she was at the beginning. And thank you, everyone. And you all have a wonderful night. And I will see you soon.